Welcome to Today and Tomorrow, the podcast in which we explore the forces shaping our world and ask the questions that matter most about the future. Today, we're stepping into a world that touches every single one of us, whether we realize it or not. Justice, the rule of law, the systems that decide who is free and who is not, what is right and what is wrong. And right now, that world is under enormous pressure from two different directions at once. The first is political. The second pressure is technological. And our guest today has spent his career sitting at the intersection of these areas. But before we get to him, of course, I'm not alone as always. Dieter, it is so nice to have you here today. How are you doing?
Yeah, quite fine. Even I'm looking a little bit reddish, I think. But I'm at the Ludwig Erhard Gipfel right now, so it's a little bit a different setting than usual. Still, I'm very happy to have Jordi here. We were sitting at another conference in November on a panel together, and we were talking about free speech in the digital age. And we realized that there's a lot that we should deepen in our conversation and continue our conversation. And I'm very happy to have the opportunity now here in our podcast.
Jordi, from my side as well, a wonderful warm welcome. Thank you that you take your time here and that you are here today. Would you like to introduce yourself to our listeners and viewers?
Yes, thank you very much, first of all, for welcoming me in your podcast. This is a great honor because I think we shall create these spaces to discuss about these sort of things that are not so common in the between the citizens. I mean, in the conversations of the citizens, even if it affects them a lot. So the fact that I'm able to speak about artificial intelligence and the courtroom here in your podcast is a really good idea. Well, who I am? I am a professor for procedural law at the University of Barcelona. And with this background, I shouldn't be really occupied in all these technological things, but I realized that juries shall take a step forward to analyze some of the technologies that will affect us in the future. Unless we do that, the problem is that we remain in the past, and this is something that happens a lot to jurists. So I wanted to break that model, and I hope that this podcast of you will help me also in this task.
You already said we are going to talk a little bit about artificial intelligence in the courtroom, and you published your book on AI in Judicial Proceedings in 2018, which in technology terms is, well, several lifetimes ago. Looking back, what did you get right and what has generally surprised you since then?
Well, the first surprise was that the book is still useful today, and this was not the idea I had when I wrote it. Well, I mean, when you write something about technology, and it was not the first time in my life, it usually gets old in about 1 year or 2 years at at the most. So you know that you are going to do something that many people is going to read in the next 2 or 3 months, but then the article or the paper will be completely forgotten. But this was not the case. So when I wrote my book, I tried to be aware of all the progresses that had been made in artificial intelligence because before they became public, they became commercial. That's what I did in my book. And this was a great advantage because I could speak of something about that no one had yet spoken about at that moment, that was generative artificial intelligence. Well, that was something new. That was something that surprised me when I wrote that book. And also, I deepened a lot in the psychological part of the imitation that artificial intelligence would do with the judicial mind. I mean, with the mind of the judges, and this is something that has kept my work useful today, because in the first in the first field, I mean the generative artificial intelligence, not a very big change has been made since then. I mean, the only change is that it has become popular. It has become commercial, but it was already know how it would work and how it was going to be useful for judicial processes. And in the second field, sorry, I mean the psychological part. Well, I mean, our mind is still the same, and psychologists have not evolved a lot in the study of our minds in the last 5, 10 years. I mean, the big change in the study of psychology on the mind was made by Kahneman and Tversky in the earlier 70s. So, and since then, we have seen a development of those original ideas, but no really new ideas have been created since then. So, I mean, taking into consideration these two pillars of my work, I mean, the book is still readable and it's still useful. And it surprises me really. It's just a pity that it's written only in Spanish, and it was translated into Italian and into Portuguese. So it still lacks an English translation, and what would bother me a lot is to have a German translation, but it is still more difficult.
Well, you still can use Gen AI for that, but well, to be honest, a technological book that 8 years later is still relevant and up to date, I think this is really Sheldon. So it's a wonderful thing. But as you said, 2018 Gen AI was in its first steps. It evolved a little bit, but let's have a little bit of a deeper look at this. Is AI, or let's phrase it differently, where is AI already mature enough to be generally useful in the courtroom, and where, in your view, is it simply too dangerous to deploy it?
Well, I mean, your question is important because the laws that have been made since then, especially in the European Union, come from the point of view that artificial intelligence is really dangerous in the court because it could substitute the judges. Well, this is not really the case. This is not really the case. I think that the people who were regulating this thing in the European Union were not so aware of what artificial intelligence really was. And this is a very big critics. But I mean, I have to say it because when you read what they say, in that law, they just forbid things, or they just say, well, this is dangerous, you shall not do this, you shall not do that, but they don't tell you why. They don't tell you the reason, and they don't tell you the frontiers of it. So, I mean, they were just trying to do like I'm sorry to say that, but as the church did in the past centuries, with a lot of discoveries that were being made at the time. They didn't understand them, and then they said, "Well, this is forbidden. You cannot use that. You cannot say that. You cannot do that." Well, I mean, it is dangerous only in some specific terms that I will say afterwards. But to use artificial intelligence, what do you need? You know that already. You need information that it's repeating and repeating and repeating itself over and over again. So if you have this, you can parameterize the process. So you can say, well, this is going to happen, this is going to happen, this is going to happen. We do things the same way, so we can parameterize it, and then you can train. I don't like this word, but you can just program I think it's the proper word. You can just program your algorithms of your tool, of your artificial intelligence tool, to do always the same thing in some domains. Well, in the courtroom, so in the judicial process, can you parameterize or you cannot parameterize?
No, but that's what, of course, it's always about programming the algorithm. And so it can be very dangerous when you promote when you code the algorithm in a specific way. But and that's a problem. We have to make sure that AI is compliant to what we want to accomplish, and that we are using it properly. And I think that is one of the fundamental problems we have when we're talking about AI, and that's the critical point about the approach of the European Union, because they just say this is potentially dangerous. Okay, we overregulate it, and we limit opportunity. And I think this is one of the major problems we are faced with, especially here in Europe.
Yes, I really think so. If I can say this, I mean, the problem is not artificial intelligence in itself. The problem are the enterprises that control or produce artificial intelligence. I mean, you can build up a tool that helps judges to decide in many fields. In many fields, you have already artificial intelligence when deciding about provisional detention. And this is something very, very extreme, so very dangerous. And you have it in the United States and in other European countries, also in Spain, but not really in this provisional detention. But anyway, again, you can program a tool to help judges to conduct procedures. I mean, to get them forward and just recognize the claims that the claimants are doing. I mean, some of them are really easy. For instance, since if someone has to be paid 1,000 euro, and it comes the day that he had to be paid and he wasn't, well, it's simple. You just have to present your claim, and then the judge will solve it. What is the problem? The problem is that the procedure is really automatical in courts, so judges always do the same, but they do it after some months that you presented your claim. Well, with artificial intelligence, if you don't have to consider anything, this could be done in about a week. I mean, it's not that artificial intelligence needs a week to decide it. You just have to let some time to the other party to answer your considerations in the claim. So it's only this what you have to do. And well, this situation that the same facts repeat themselves, it's a really frequent situation. So it doesn't. It is not something that doesn't happen a lot. It happens really a lot. I mean, when I have talked to judges of many countries, also from Germany, they always tell me that at least in the civil jurisdiction, not in the criminal one, but in the civil jurisdiction, or in the work jurisdiction, or also in the administrative jurisdiction, most of the cases are alike. And when I wanted to know a number, because there is no statistic about this, so I just asked them about an intuitive number. So I mean, coming from the experience of someone who occupies himself or herself with this, no, they always quoted between the 80% and 90%. That's a lot. That's a lot.
It it actually is quite a lot. But we talk about training, programming the algorithm, and helping in things that come up again and again. But there's this old saying, algorithms are only as unbiased as the data they're trained on. And we know that historical data sometimes, especially also legal data, is riddled with racial, social, economic biases. Isn't there a real risk that algorithmic justice doesn't just correct inequality, but simply automate it?
Of course, there is a risk. Of course, there is a risk if you let them at those enterprises to do that. But what you have to do as a government is to consider that artificial intelligence is not a sector that you can let in private hands. It's an strategical sector as important as the military. I mean, this is not a joke. This is something that you have to take very seriously into consideration. Well, you can remember how Vladimir Putin put in the past in private hands his military, and what happened with this Wagner squad that practically get rebelled against him. So he understood that you cannot let that happen. So with artificial intelligence, it's the same thing. Governments have to develop their own technology if they want to use that in the government areas or in the judicial areas. Unless you do that, you are letting a big enterprise to program the tool in the way that it's more favorable to them. And this is something that they are going to do, of course. Of course. Because, I mean, there are no innocent people when we talk about money, when we talk about political interest, or also about ideological interest. And I mean, if you let one of these enterprises to control your administration or control your judicial sector, your courts, you are going to influence over the population. If you do it with your judges, you are just giving these enterprises the power to say what's wrong and what is right. And this is something that orientates the population. So governments shall develop with enough democratical controls these tools so as none of these enterprises would control at the end of the day the model. Unless we do that, well, we could lose the control. Of course, we can. I have written about that, an article that was also translated into Italian and into other languages. I don't know if into English, I don't remember anyway. But anyway, I was explaining not only how could this happen, this is easy to understand, but also how it could be prevented. I mean, how can you do if you are the government and if you are the parliament to regulate this sector and to produce the tool in order to have an always independent judiciary and not dependent on some enterprise?
What I see is it's also a matter of the mindset because, especially, governments and also legislators are very much rooted still in what I call an analog mindset. As long as they don't start thinking digitally and adapt to the new situation, it will be very difficult yeah, to get it right because you're just coming from the wrong paradigms, and this makes it very difficult to use AI properly and in a rewarding way, socially a rewarding way, um, and not seeing it as a risk, and use the opportunity and develop the opportunities to a much higher degree than it's possible today. But also the legal system, I think, they need to become much more compliant to the new digital world, uh, rather than over-regulating things and trying to uh, get every detail under control. we should see to come to more open systems that can react more flexible also to the speed of technical advancement.
We need to be following the technological advancements. That's totally true. But there's one thing, Jody, I need to step in with. We were talking about that we should train the algorithms. We should have a look on what we give to the companies and what not. But there is this other way. Already seen lawyers submit AI-generated citations that turned out to be entirely fabricated. So in the best case, of course, we train it, we teach it, we program it, and it works fine. But then there are the other ones who think, well, ChatGPT, Claude, it will be totally fine. Let's use this one. We don't need to train anything. It will happen automatically, because the biggest problem with AI is it's so clever. It's always so polite. And it will give us psychologically, as we already talked about it, the feeling of this is right. You can use this for your case now. So how can we tackle this?
Well, it is not easy to tackle this because it's easy to use, and well, the fact is that judges all over Europe or all over the world are using ChatGPT or other artificial intelligence technologies to write their judgments. Some of them have been also sanctioned because they did that, and it was discovered. Well, I'm not really. I don't really agree with these sanctions because it's not the first time that they do something like this. I
Mm.
mean, the tool copy paste exists for about more than 20 years, and they have used that a lot. And also, they have invented the numbers of judgments or also the quotations. I mean, as a researcher,
Hmm.
I know that many times that I was reading a judgment, I was trying to find what they quoted there, and I couldn't because it didn't exist. So this is not a new situation. So now it got automatized.
Mm.
Automatized. This is all. But in order to help them not to use these tools, well, as a government, you have to build up the tools. So the fact that the judges are using it, it just tell the politicians, well, please do something for us, because unless you do it, we are going to do that anyway.
Hmm.
I mean, it's urgent that our governments, with parliamentary control, of course, try to finance someone to do that in order to have a really good tool that help judges in order to look for case law, look for the laws, also propose some text that they can copy and
Hmm.
paste or they can use them automatically, or also the judgment that some judgments were written automatically, because it will help a lot of people to have a judgment much before the date that they used to have them now. So, I mean, the thing that we are watching now is just, I interpret as
Hmm.
that just a help cry, I
Yeah.
mean, I am using this in my everyday life, so why cannot use it
Yeah.
in my work? So that's all. And in this situation, the governments can say, well, okay, you keep using that, but this is very dangerous. Or we built up a tool just for our laws, just for our country, just for our case law, and this is what they have to do.
Let's be honest. Let's say we build up a tool for us, for our country, for our law. This is a wonderful thing. But then there is this one thing you also always talk about, the human factor, or the human in the loop, as the people always say. Especially if we have a tool that can help us, we still need our logical thinking, our experience as professionals to have the final decision. Wouldn't you agree?
Yes, of course, because when you do this, so when the government says, well, I'm going to contract these guys to build up the tool, they have to make a good selection of the guys that are involved with this construction, and also they just not have to have a selection in terms of technological or scientific level of the people that are involved, but also of the democratic values of those people, because these people also, if they don't aim to do that, could influence the tool, would influence the system. I have talked a lot about this with some experts in information technology, and they have told me, well, we are not jurists. We hardly understand what you are ordering to us, so we will just repeat what you are ordering to us to do. But this is not always the case. Some of them should have ideological pretensions. I mean, should have some ideas in how to develop the society in some of the fields. So some of the issues should be controlled by us. I mean, by the population, so by our government and by our parliamentary, and that's what we have to do. If we lose this control, so if we select the people just because they are very brilliant in scientific terms, but we forget about any other control after that, and we forget about their democratic values, well, it will be a failure, of course. This will be a failure.
Well, I just wonder if because well, when we were talking about free speech in Barcelona and how to protect it under democratic rules. So maybe it's a good moment to move over to this issue again, because I think it's dear to both our hearts. And I also see the problem with the human factor, or with the human in the loop, because um, and with the analog thinking, because when we are confronted with fake news, of course, fake news suddenly become very loud, but it's addressing the people that already were approachable for fake news. So, and they were even in the analog world, and there is not really anything new. We just hear them louder, and the reaction is helpless, and and this is endangering free speech. Um, the question is, how can we handle that? How can we develop a kind of literacy or responsibility to deal with it in a democratic way? What do you think?
Well, it's a good comparison. I mean, the judicial activity and the freedom of expression, because in fact, what the journalists do with freedom of expression is something that can become, of course, dangerous. When I have good news in this issue, because our judges are not as free as our journalists. So our judges are submitted to the law, so they have to obey that. And you already have a control to, in order to check that they have already done that. I mean, you have the possibility of appealing their judgments. So this control is not possible when you deal with journalists. So, I mean, will this control be enough to control that the tool really works in the proper way? Well, I mean, this is something more that you don't have with freedom of expression. But again, I think the control shall be done not only in the application or the use of the tool, but also in the construction of the tool. I mean, this is the most important moment, because we have to think about that when using the tool, uh, all the judges will use the same tool. I mean, not only the judge in the first instance, but also the judge in the second instance or also in the third instance, I mean the appeal judges. So if they all use the same tool, they are not going to correct themselves because the tool will always give the same answer. So we have to control that the tool is organized in the proper way because before it's being used by the judges.
Jordi, we talked a lot about possibilities. We talked about how it's currently working and how it should work. But let's do a little bit of a thought experiment. It's 2036. Walk us through what a typical court case looks like now in the future, 10 years ahead. What would you say? How would the future of the court look like?
Well, I mean, there is a difference between what I should desire, what I should wish that it looks like, and what will it actually looks like. So, the second question, what it will look like, more or less alike it is as it is today, because tribunals don't usually change that fast. This is something I try to struggle against, but I mean I am one of the very tiny number of professors that are doing this instead. Most of my colleagues want to keep always things being traditional, being the same way, and that's maybe this is more comfortable. You don't have to work, you don't have to think, so you just have to repeat itself. So you are artificialing your brain. You are making your brain work like artificial intelligence. So this is something that we don't like. But I would what I would like to be well. I think that in the next 10 years, a lot of cases, a lot of procedures could be selected to be resolved in an automatical way. I think this is possible. In the civil jurisdiction and in the administrative jurisdiction, this is for sure. A lot of them, lots of claims that we have now in our tribunals would be resolved in just about some days. And I am not only talking about debts, for instance, I'm also talking about divorce, for instance. Something that you need to do really very fast because it affects your personality, it affects your psychological well-being, and of course this is something that it lasts a little bit in the tribunal. So I think some of those cases that are really always the same and judges always do the same, they could be parameterized and in about 10 years we could have a situation where we don't have any more courtrooms in these cases, and we just have a machine rendering the judgments in those cases. But if I want to be more, I don't know how to put it, but if I want optimistic or to dream more about that, I will I will be imagining that in the future we will see that some things disappear from tribunals, and there will be all those things that science, either science or technology, have told us that are absurd. Technology have told us that judges always behave in the same way because they repeated the process, so you cannot automatize it. And science also has told us that many things that are being made in a procedure are completely absurd. And I am talking not only about the hearings, but most specifically about interrogations. We know from more than 100 years that interrogations are completely useless because no human being can interpret who is lying and who's telling the truth just by watching the face or just by watching reactions. And also, we have to take into account that human memory is very tiny, so it's not as perfect as we think it is, or as in the procedures is thought to be. And this is not something new. This is something that has been checked and developed in the last years, but this is something that was already experimented 124 years ago in Berlin by someone very well known in Germany, Franz von Liszt. So he was a criminal law professor, and he did an experiment that is published in the Juristenzeitung of 1902. And well, it's just 4 pages, so you can read it and you can see how Franz von Liszt was saying, please stop with interrogations. It's enough. They are completely useless. We don't really need them, and they are really misleading because the results of interrogations just are linked with our social prejudices. This is something we discovered more recently. But taking all that into consideration, then you have to exclude this means of evidence from the procedure and to substitute it by by of course better means that could be also helped by artificial intelligence, like expert evidence. I mean, this is the future of the procedure, in my opinion.
But yeah, it's all about it's all about people, and we just started the debate on deregulation and on bureaucratization. And I think this provides a chance also to streamline our legislations and to make it more, well, how should I say it, AI compatible and uh, deep tech compatible and adapting to the world. And but I agree with you, Jordi, that it is very difficult to get this into the mind of people and of the actors in this field because nobody likes to change, and so things tend to be very stable for way too long a time. And we have to see how fast we can solve this issue because this will be vital if we want to well. It's a big word to say to survive in the digital world, but to be able to prosper in the digital world. I think this is a better way to put it.
Yes, I completely agree with that. So, I mean, the thing I'm trying to tell judges, all tribunals, and all jurists well, not only in Spain, but in all the countries where I speak about this issue, is that we cannot ignore technology. We cannot ignore that this is not coming. We are already using it. We are actually using it. So if you don't want to have an uncontrolled usage of this technology, you have to adapt and you have to construct how I told you this tool just for for every country's regulations. This is something that you have to do, and this is, I mean, this is something I I really I really don't understand why they didn't do that. Maybe it is not so popular among the population. This is not something that politicians could sell in elections. But this is something that is really dangerous because I mean we have shown how we have seen how other foreign governments have tried to influence us through the social networks. I mean, why shouldn't they do? Why shouldn't do they do the same thing with generative artificial intelligence? In fact, we know that they are they are trying to do that now. So I mean, this is something you have to get worried about.
I think this is a wonderful final approach and appel for all the people out there. Jordi, what are the final words you would tell your colleagues, tell everyone out there, the policymakers? the countries, the diplomats, what to change right now to make the future we are talking about, which was optimistic, of course. A future that is not optimistic but possible.
Just to put it in a few words, stop regulating. You are doing nothing with it, or only with it. Stop regulating and start thinking how you build up your own artificial intelligence systems, or at the same time. So regulate and build up these systems. What you cannot do is to regulate them if first you don't understand how they work. Second, you have no plan whatsoever to build up such tool. So I mean, we have to completely change this approach if we want to succeed in the future, and we don't want to harm more our democracies.
I fully agree with you, Jordi, and it was a great pleasure talking again. And I hope we will continue this conversation on one platform or the other. And yes, we have to stay proactive and pro technology because it's coming over us, and we can't change that. It's either we live with it, uh, or if we neglect it, we are controlled, and we are not in control anymore. So actually, I think it was a very vital debate we had here today, and yeah, let's continue.
I would agree with this, and what a conversation. I think what strikes me the most, and Dieter, you already said it, it's not just how the world of law is changing, it's how fast it does, at least if we agree to it and if we not ignore it. Johnny has been thinking about all these changing questions longer and more rigorously than anyone out there in Europe, I would assume. And what I take away from today is not pessimism, because we talked about it, but urgency. The tools exist, the knowledge exists, and what we need is the political, the institutional will to use them wisely and to build up our own thing. So again, from my side, a very warm welcome, a very warm, and then again from my side, a very warm thank you for you, Jordi, for your time, for the wonderful exchange. To all our listeners and viewers, thank you for listening, for viewing this new episode of Today and Tomorrow. If you liked it, we would love you to subscribe to it, to give us a comment, to rate it on Spotify if you want to. And as always, the final words go to Dieter and Jordi. So, from my side, thanks a lot, you guys. See you next time.
Well, thank you, Alex, for your guidance into the future. Thank you, Jordi, for your expertise. And yeah, I really enjoyed it.
So thanks a lot, Alexander. Thanks a lot, Dieter, for being the the bridge between Alexander and me to have these conversations, and really enjoyed that a lot. But I think that we shall speak more in the future. So when you feel that you that you want to make a conversation about that again, I am more than ready to do that. So thank you very much.